Court rise for approval. This is a part heard appeal in the matter of Stratford, which is the
Yes, good morning, my lords. Just on a point of housekeeping in relation to the photocopying of the page references yesterday.
Oh, yes.
This day I wasn't responsible for it. There were, I think, about 100 pages that were double copied. So the case of G&D appeared twice, amongst others. They were removed in the hard copy, but obviously it didn't make sense to notionally remove them from the electronic one. But I'm pleased to say I'm not going to be referring to any others that were double copied. So we should all be literally on the same page. Right, I'm going to start with the reference to the LPI regs and still buried, so to speak, within ground 1.2. And the context of this is the support, not exclusive support, but the support that the First Tier Tribunal took from this regime as pointing towards developers, notwithstanding it was an inter-landlord arrangement. Yep. It's in the core authorities bundle at tab 6 are the regulations. These obviously, and the way it works is that they refer back to paragraphs under Schedule 8. So if we go to page 92, tab 6, Regulation 3, recovery of amounts from other landlords, is cases under paragraph 2 of Schedule 8, which I'm going to take you to, but if you want to actually write it on the page, you go back to tab 4, page 68 for that. And then if one goes to Regulation 4 on page 95, that's recovery of amounts from other landlords, cases under paragraph 3 of Schedule 8, and the reference for that is tab 4, page 69. And then Regulation 5 on page 98 is other cases under Schedule 8. We don't need to go to that. So reverting back to Regulation 3 on page 92, this is the regulation which applies where a landlord has paid or is liable to pay the cost of a relevant measure related to relevant defect, which but for paragraph 2 of Schedule 8 would have been payable as a service charge by a tenant under the lease. So this is the regulation and paragraph paired up that we say is at the top of the tree. And one goes, therefore, for the meat of this, to page 68 in tab 4. So paragraph 2, no service charge is payable under the lease in respect of a relevant measure relating to a relevant defect if a relevant landlord is A, responsible for the relevant defect, or B, associated with a person responsible for. And the definition of responsible for is in subparagraph 3 and materially A. In the case of an initial defect, the person was or is in a joint venture with the developer or undertook or commissioned works related to the defect. So there is the concept of the developer appearing as the entity responsible for the relevant defect, and developer is defined in subparagraph 4 as the person who undertook or commissioned the construction or conversion of the building with a view to granting or disposing of interests in the building or parts of it. And the key feature on which I rely in this regard is that definition of developer is the same as the definition of developer in section 1245, subparagraph 5, which is earlier on in this tab at page 31. So section 124 being RCOs with which we're directly concerned, one can see in subsection 5 the definition of developer.
Is there any significance to the green shading?
I think it's a link, because there's a print of an electronic copy. I think any statutory cross-reference, I presume, I didn't create this, but I think if you click on it, it will take you to some other legislation. So that's how it works. And in the case of going back to Regulation 3, the point that the tribunal was making was, well, in this particular, well, so let me start. So the point is that the top of the tree is Regulation 3 in paragraph 2, the developer. That's the waterfall point. I've now hopefully clarified that. The second, the point is the way the Regulation 3 works is that a notice is given. I'll take this very shortly. It's page 92 and 93 in tab 6. A notice is given by one landlord to the other in respect of what he's been asked to pay. And in subparagraph 5, a person who's notified of a requirement to pay can appeal within 30 days, specifying the grounds of appeal. The grounds of appeal are very limited in subsection 6, that the remediation amount doesn't represent the cost of the relevant measure, or that he's not the responsible landlord. And the definition of responsible landlord is in subsection 8. So it's a fairly summary process, and the grounds are limited. As you've heard in the note that was handed up, EVML, as a matter of fact, in this case, have served a Reg 3 notice, and there are issues raised in the context of those proceedings. They are issues which are, as I understand it, internal to the grounds of appeal in subsection 6, and external in the sense that it's also said that it wasn't a valid notice at all, which wouldn't go to the FTT. As I understand it, that would be a jurisdictional question for a court. But the point is, so that process and procedure is underway. None of that, however, undermines the FTT's conclusion that the Regulation 3 point was an unanswerable route. Of course, those proceedings hadn't been started, as a matter of fact, until comparatively recently. But unanswerable was the expression used, not in the sense of saying there can't be disputes of fact or jurisdiction in relation to the detail of Reg 3 notice, but as a concept that it was unanswerable.
Was it just as a concept?
Well, it was saying that the capacity, essentially, EVML, it was saying, not triathlon, but it was the FTT was saying that EVML, in principle, could have served a Reg 3 notice on SVPH 1 and 2, that's the freeholders, requiring them to pay the remediation amount, i.e. the sums paid to Errigal, of which some had existed at the time that the FTT made its decision. And the point here is that SVPH are trustees of SVDP, the beneficiary. That's recorded in the decision, and there's also a property chart that I can give you the reference for in the supplementary bundle, section A4, page 17. There's no need, I think, to turn it up. But SVPH, the freeholders are trustees for SVDP, and in fact, they're also subsidiaries of SVDP, one of the SVDP partners. And so the point, as it's expressed by the Upper Tribunal, if I can just page 265. So it's tab 11 of the core bundle, and it's page 200.
Do you have the paragraph?
I do, 265.
Sorry, I beg your pardon.
And they, in the middle of the paragraph, they refer to the regulations, and then they say SVDP is literally in the middle of the paragraph. SVDP, or to be strictly accurate, SVPH 1 and 2, which hold the freehold on trust for SVDP, is the responsible landlord, and it and its associates would therefore be under an obligation to pay costs of remediation, which would be met by other landlords if they were served with notices. That's not the route to recovery which was being pursued in these applications, and that's correct because Triathlon wasn't in a position to serve them. And Section 124 requires us to additionally be satisfied it's just and equitable. But the availability of an alternative and unanswerable route to the recovery against its trustees is a strong indicator that it's likely to be just and equitable for SVDP to be ordered to pay. So the point I'm making is that although there may be some disputes of fact in the FT working its way through the tribunal system as to the scope and content of the notice, that's not the point that the FTT were making. They're saying in the context of just and equitable, it looks as though there's a system in place which one way or another can get to SVPH in respect of costs incurred, and SVPH is the trustee of SVPH 1 and 2 are trustees of SVDP. That's the context of the decision, and that point, in that understood in that way, one understands the point about unanswerable isolation. That's the point that's being made, it's not, as I say, undermined by the subsequent disputes that are now emerging on the notice. Now, my learned friend, Mr. Selby, says, well, that will be an order against different parties. That was the submission he made yesterday. And we submit that that's the distinction without the difference in the just and equitable context, because it would be standing on the fine distinction between SVPH 1 and 2 and SVDP on the other. That's we say, a distinction without a difference. There's a further feature of this case, which perhaps is just worth dwelling on. You may have picked up that, as originally pleaded, the case was that Get Living were associated with SVDP in its capacity as the parent, essentially, of the developer. And that was contested as a matter of principle. But it was accepted that Get Living were associated with the freeholder, SVPH 1 and 2. And you'll have seen that by the end of the case, the FTT decided that it didn't need to decide whether, as a matter of law, Get Living was associated with SVDP qua developer. And so, and the reason they said, and one can see how, in a given case, the circumstances or the role through which you are associated would be material to the just and equitable. In other words, the fact that you're associated associated with the freeholder shouldn't, in another case, be seen to treat you, as it were, as the associate of the developer. Their roles and so on are different. But in this case, there was a concession that, in effect, that it made no difference. And therefore, in light of that concession, the FTT didn't decide that point, which they said they would leave to another occasion. I can give you the reference to that if I need to. The point is, although the basis of the concession that it made no difference in this case, or the rationale for it, was never explained by my learned friend, means. They just said, we accept that the role through which you get to get living doesn't matter. The only rational basis for that concession must have been the absence of distinction between SVPH in their role of trustees and SVDP as beneficiary, SVDP also being the developer. So in a sense, it all hangs together. The reason the FTT didn't need to decide the distinction was the facts of this case, which connect freeholder and developer. And in those circumstances, again, one reads paragraph 265 in that light, in our submission. That is all I want to say about ground 1.2. Ground 1.3 is the relevance of motive and identity of the applicant. The paragraph 246 of the decision on page 196, you'll remember it's been drawn to your attention that the tribunal did not consider it relevant to draw conclusions about Triathlon's motivation in bringing these applications, and it records the director's evidence stressing the importance of safety to the leaseholders and complying with Triathlon's responsibilities to the agency to maintain standards. So Triathlon was itself subject to contractual obligations. And they say it wasn't suggested it was an improper motive. And ultimately, they didn't need to make any findings about why it seeks the orders. Parliament has made them available, and Triathlon is entitled to avail themselves of it. In essence, this is a question about the applicant's subjective motivation. And in my submission, they're right to conclude, the tribunal was right to conclude that subjective motivation was irrelevant, absent any improper motive. This is followed up in paragraph 271, where they said, they say at page 202, paragraph 271, we've already said that we do not think that the motivation of an applicant will usually be of much significance, and we do not think it matters much who the applicant is. Just pausing there and picking up the distinction that Lord Justice Holgate has made, that there is at least the concept of weight being attached, even if ultimately it's nil. So this is a weight point, we would say, in any event. And we say in our submission that there's a distinction between subjective motive and, so to speak, the situation of the parties. In other words, one's entitled to understand who the applicant is and where they sit in a framework. But saying, I'm applying for an RCO because I don't like them or whatever, isn't perhaps we would submit a material consideration. And that, in a sense, is what the FTT is saying, absent some form of malice. And we accept that the situation of the parties, objectively viewed, which is not the same as subjective motivation, is perfectly permissible. Again, for what it's worth, there's a case called the Gray and Secretary of State decision. I'll give you the reference, we won't need to take it out. It's Core Authorities, tab 12, page 330, paragraphs 122 and 128. There, the FTT rejected the motivation, the political motivation. The Secretary of State had been involved, and there was a question as to whether their motivation was a political purpose, and that undermined the application, and the tribunal said we're not interested in.
Just reading this again, the first sentence says, we do not think it relevant to the exercise of our discretion to draw conclusions. Again, it's not suggesting, in one reading, that motivation is, even subjective motivation, is entirely irrelevant. They then go on to record two competing views as to what the motivation was, and they're saying, well, we don't need to decide this.
Absolutely.
Particularly in the absence of any suggestion of bad faith or improper motive.
Absolutely.
They're saying it could be either.
Yep. we respectfully agree. And my learned friend hasn't said, by the way, why the motivation to which he does attribute to us, namely the avoidance of liability for the costs, why that becomes a factor against making an RCO, even if true. After all,
That's what you're trying to do.
well, A, it's what we're trying to do, but B, it's the flip side of what they're trying to do, which is to deny being liable for the costs. They're opposing the order for the obverse reason, and so it ends up being a neutral point even then.
Okay. Can I just talk around it for a moment? Plainly, Triathlon had standing because section 1245 gives it standing.
Yes.
I mean 1245. I think I probably do. What ultimately has happened here is that the money does not go to Triathlon, it goes to EVML, which was not making the application. Is it relevant to ask not merely whether an applicant has standing, but what the nature of its interest is in an order being made?
As I said, yes, I would accept that. That's what I meant by the situation
Yes,
of the parties. Because one's looking at their standing in an objective way. The answer, my own friend says, we still don't know as of today. Well, respectfully, that's just not an answer. The answer is as plain as a pikestaff. Justice Holgate obviously alighted upon it. It was the boardroom battles.
Yes.
It's paragraphs 194 to 204 recite the huge disagreements which existed between the parties, entirely unsurprisingly as a result of the juxtaposition which they had been presented with as a result of the Building Safety Act, with a board controlled, the board being a combination of, colloquially, triathlon people and get living people. It's more sophisticated than that, but with the controlling interest of the board being get living. And the difficulty was the works were not being done. The progress to secure the works was not being done. There was huge debate about the scope, all the rest of it. There's plenty of material. And in the ordinary course, in a normal world, of course the management company would be getting on and dealing with this. But it was locked. And Triathlon had its own responsibilities and its own interests to secure the completion of the works and the safeguarding of its residents. And that is obviously the position in my submission, and it's paragraph 15 of the decision recites what actually happened. Page 153 of the bundle, paragraph 15. This is right at the beginning of the judgment. No order for payment is sought by Triathlon against EVML. Rather, as the proposed recipients from others, EVL was joined as a respondent at the suggestion of the FTT to enable it to participate if it chose to. Until a few days before the hearing of the applications, EVML took no active part and was not represented. And that is what happened. And then at the very last moment, for various reasons we don't need to go into, the learned friend, Mr. Polly, was instructed, and he provided a written note from which the FTT drew some support. But Triathlon did the legwork, so to speak.
And just so we're absolutely clear, Triathlon is the social landlord, isn't it?
Yes.
To be explicit, what is the nature of its financial exposure, or was the nature of its financial exposure, as opposed to its wider responsibilities in terms of concern for its tenants generally?
It would be responsible. Well, I don't know the direct answer to that, but I mean, it has a responsibility in respect of the blocks that, or the blocks in which it has the principal share. But there are 5 blocks. There are obviously lots and lots of blocks, but this RCO dealt with 5 blocks, and those blocks which had a predominance of social housing, Triathlon would have been immediately responsible for the greater.
I think there are some blocks where it was 100% responsible for the accommodation.
Yes.
Set out in the decision.
Yes. Yeah. So significant costs.
Yes.
I thought we were told by Mr. Selby that Triathlon was not liable under the service charge provisions to contribute to the cost of the works being carried out by EVML. Is that right?
Triathlon but Triathlon had responsibility to repair to its tenants.
Yes, I understand that. But if EVML is in fact doing the work to all 5 blocks, funded by the Building Safety Fund,
Yes.
then that discharges Triathlon's obligation to its own tenants, does it not?
As a matter of fact, yes.
So what is Triathlon's potential exposure? I understand it has a contractual liability to repair, but if that's the thrust of Mr. Selby's submissions, as I understood them, was these provisions are designed to ensure that the money is made available for works to be done, but the works are being done and the
Yes.
money is available.
Yes.
And it's just an argument between the Building Safety Fund and his clients as to who has to do the forward funding. That was the thrust of what he told me.
Yes.
And I'm not entirely clear at the moment what interest Triathlon has in that question.
Well, it had the interest in ensuring that. So there were a number of questions as to. Triathlon had to wanted to ensure the smooth passage and operation of the building contract. Obviously, the tribunal ultimately found that when the Building Safety Fund came through, that was secured. But at the time the applications were issued, that hadn't been the case. So
I don't have the chronology in mind. When were the applications brought?
December 22. Sorry, December 23.
22.
22. Apologies.
And when was the grant funding agreement with the Building Safety Fund finalised?
July 23.
June, 1st of June.
1st of June.
And the contract by EVMO for the works?
August 22, I think.
Chronology's in the main bundle.
Yes, there's a chronology in the tab 10. Says.
Thank you.
So I think the December, so 15th of December 2022, Errigal contract entered, page 146. So that's not. So my answer wasn't quite right. The applications were issued 4 days later.
Yes, I see.
Could I just clarify this? I'm sorry if I've not grasped it. But if we go to the order made by the tribunal,
Yes.
Tab
12.
Tab 12.
Yes.
I thought what we were being told in part was that the public funding was referable to the items we see on page 211 of the
That's
court
correct.
bundle under order 4.
Correct.
But not orders 1 to 3.
Correct. And those are the ones that's the. So.
But they refer in
those
many
are
cases
triathlons.
triathlon's share of responsibility.
Yeah.
I mean, they are the smaller sums, but
Yeah.
they're not zero.
The problem is interpreted the question as having been asked in the context of ground one.
Ground one only applies
That's,
to...
yes, yes. That's very
But those are what we call ground two and ground three.
But if one's stepping back to ask the
why we were an applicant at all.
why you were there at all,
We were there at all, at the very least, to recover £1,500,000. As opposed to why we were asking for a wider cost.
Yes.
So 1 and 2 is money where you're asking for money to be paid to you
Yes,
to reimburse what you have paid to EVML.
yes, 3
3 seems to be paid directly to EVML, but that's money which you would otherwise be liable for.
correct.
4, 5 and 4, A, B and C,
They're sums to which EVML is committed under the building contract and or other parasitic expenditure.
which you would be liable to pay under the service charge if you were liable, but you're not.
Correct.
So ground 1 only deals with the sums in paragraph 4.
Yes. And we were not asking for the money for ourselves, we were asking for the money to be paid to EVML, who themselves had not made Section 124 application.
And at the stage at which you brought it in December 22, the grant funding agreement had not been signed up.
That's right.
But by the time it comes to be heard, EVML has the grant funding. And at that point, the sums in paragraph 4 do become just an issue between Get Living on the one hand and the Building Safety Fund on the other hand, as who has to
Yes.
forward fund the contract.
Yes.
And on that, what is Triathlon's interest in that question?
Well, depends what one means by interest. But we have
Okay, what is EVML's interest in that question? Whether they're funded by the Building Safety Fund or whether they're funded by Get
well,
Living?
I anticipate Mr. Polly will address you on that. I wouldn't want to speak for him.
But you told us that one reason Triathlon brought this application was because EVML was deadlocked. So
Yes.
Triathlon was really doing it because EVML couldn't.
Yes.
So is not
But-
EVML's interest in pursuing it a relevant matter for you?
The point is, Mr. Polly now has a voice, so to speak.
Okay.
At the time we issued, I was really running the case, so to speak, with an object in mind. Now we have a representation that can address you directly as to EVML's position, which of course was then and is now supportive of these applications.
Yes. And what is Triathlon? Can I get back to what is Triathlon's interest? Once the grant funding comes through, and the question is who has to forward fund the contract? Is it Get Living or is it the government? What is Triathlon's interest in that question?
Triathlon's interest is in the smooth safeguard, the smooth operation of the works without dependence on the Building Safety Fund, in order to, including, I should say, that the terms of the Building Safety Fund agreement are complied with. And I'm going to come to that because there's a slight circularity to this, because the Building Safety Fund, I don't want to jump ahead of myself, requires the prosecution, we would say, of RCOs.
Right.
The last point on motivation is that the FTT, I think we made this already, does not say that motivation is always irrelevant, only it won't usually be of much significance, and that's a weight point. Then the second point under ground 1.3 was identity of the parties, as I've given you multiple references in paragraph 35 of my skeleton, there are many circumstances in the decision where the FTT considered and was well aware of who the applicant was. And we respectfully endorse paragraph 271 of the FTT's decision, where they conclude that the basis of eligibility should not be a significant feature, but in any event, that's a matter for the tribunal's discretion. A point had been made by my learned friend, which didn't result in any oral articulation yesterday. That, for example, it was a submission I think he did make at first instance, and he made it in his written skeleton, that, for example, the tribunal should have taken into account the fact that neither the Secretary of State nor the regulatory bodies such as the local authority or the fire authority had made this application. He didn't draw on that, as I say, orally. He made the submission, in effect, that an RCO, the case for an RCO, would be stronger if it had been supported by a public body. And our submission, as I said, it's not clear if it's pursued, but to say that applications made by a different entity might have been stronger tells you nothing about whether it's just and equitable to make the order that's sought by the applicant. It's a hypothetical consideration. And indeed, it would require every case to be tested by reference to whether our financially stretched public bodies had or hadn't issued their own application alongside the actual one. It would lead to speculation as to why they may or may not have been involved, and so on. And anyway, even if all of this was a real consideration, it was one for the FTT to weigh up. And there are really no findings of fact in this domain upon which the appellants can rely. So much for ground 1.3. Ground 1.4, the public purse would be the underwriter risk of failure. And there's two parts to this. The first is what I would call the Galliford Try litigation. And the second part is what's being described as the public purse argument. The last three lines of the expression risk of failure comes from the bottom of paragraph 278 of the decision, page 203, where it's 4 or 5 lines. Even if we were persuaded that the Building Safety Fund could be confident of this result on the facts of the present case, and the result is successful litigation against third parties. And we are not in a position to be so confident. So, pausing there, finding of fact by the FTT of a lack of confidence in a piece of successful litigation against third parties. We do not see why the public purse should act as interim funder and underwriter of the risk of failure while claims against third parties wend their way to a conclusion and then agree with a submission of mine. So that's the context of risk of failure. So the risk of failure is something less than the 100% recovery of a damages claim against third parties. And as I say, there's finding of fact binding on this court. There could be no confidence in that. My learned friend says, well, this is all about timing, and invites you as part of his alternative order to make an RCO that follows the conclusion of such litigation. Well, the question must be asked, why should we wait? At the stage, as it was before the FTT, the position was that there had been lamentable progress in the prosecution of the action by EVML of Galliford Try. They had served a pre-action protocol letter in September 2022, that's paragraph 210 of the decision, and as I stand here today, there are still no such proceedings issued. There are also real, Mr. Polly may or may not develop this, but one can see some real difficulties with that litigation, including security for costs, how the litigation is going to be funded, leaving aside the obvious risks of uncertainty, delay and cost of all kinds, and the, if I may say, inevitability that if there is to be, quotes, a successful outcome in terms of, for example, a negotiation, is always going to be less than the amount that would be the subject of an RCO. That would be an entirely unsatisfactory result. As for...
Galliford Try was the design and build contractor?
Yes. As for, and that's in respect of N26, which is the, so various blocks were given to different contractors, but all the blocks with which this RCO is concerned were Galliford Try.
You would have thought that if there was a defect, there would be at least a prima facie case against the designer.
Well, I'd agree with that, but there are complex technical issues, sophisticated expert evidence. That's perhaps more of what I spend my day doing. Questions of fitness for habitation, questions about the extent of fire risk. All of those things have to be.
TCC cases are never straight.
We like to think so. And then what we heard yesterday, which I'm about to say we didn't know, as far as I'm aware, is that SVDP have now issued their own civil proceedings. My friend Mr. Selby, that they have issued a pre-action protocol letter. And this is perhaps unsurprising, you might think, that in light of the lack of prosecution of an action by EVML and the decision of the FTT, that SVDP, who have contractual warranties and all the rest of it, have now themselves woken up to as I'm bound to say, this whole regime envisages should be the case. And they've issued their own pre-action protocol letter. But I think from the date my friend gave yesterday, is itself nearly a year after the FTT hearing. So there's still no proceedings on hand. One assumes it's going to be a number of years before those proceedings wend their way to adopt the description in relation to the Galliford Try litigation. These are even further behind. So we're talking about a very long time away. And not only that, but the timing of all of that would be very much in SVDP's hands as the claimant. So this idea that they don't have to pay on the RCO until the conclusion of the SVDP litigation, if that's what they're now suggesting, it gives them control over
You say if that's what they're now suggesting, what was that alternative version of an RCO put forward to the tribunal?
I think it may have been, but obviously then in the context of the Galliford Try litigation, because that was the only one in prospect at that time. I can't be sure, in fact. It was.
Thank you.
And one can also see in terms of operability some quite tricky, it may be a question of drafting, but what does conclusion of the litigation mean? Does it mean appeal? Does it mean recovery of money? There's all sorts of questions that might arise as to when an RCO, if it's a follow-on order, when it would be triggered. The other point, I suppose, whilst on this Galliford Try or SVDP litigation, that just on this alternative order point, we would submit it's really completely the wrong way round from what has been envisaged by this structural scheme to postpone the making of the RCO until after the conclusion of the civil litigation that's going to run for some years. It's the obverse of what's intended. The structural scheme here is, if one takes it, starting with the leaseholders, is to release them from the obligation, passes the weight of cost onto those responsible either as landlords or as developers. And then, given that they are, so to speak, holding the baby, give them enhanced rights to pursue civil litigation with the enhanced DPA, Defective Premises Act claims, longer limitation periods, all the rest of it. So they're not left without recourse. The whole scheme is balanced in that way, but from a funding or interim position is concerned, the RCOs are there for the immediate term, and then there's long-term recovery through civil claims. So we would say that to make an order that sits past the civil litigation is completely contrary to the statutory scheme looked at as a whole.
You referred to enhanced rights, and I understand the limitation periods have been expanded for DPA claims. But I think the actual cause of action has been expanded as well.
It has. I was going to come to that later, but I'll
I'll
answer it directly now. So the back in the day, one of the issues under the Defective Premises Act was whether is that it's only triggered by works undertaken in connection with the provision of the building.
So it's the original building or the original conversion.
Correct.
Whereas subsequent cladding put on an old building wouldn't fall within that.
Exactly. So Grenfell Tower itself is an a fortiori example of the new enhanced rights. So we can look at this.
Much of the cladding was to put on old buildings, firstly to make them look nicer, and secondly because they were thought to be other advantages. Wrongly.
Yeah. So the DPA would now cover that latter phase of work.
But that isn't a factor here, is it?
No, it's not a factor here. It crops up. I'll come to it.
Yes, you're talking about the structure as a whole.
Yes, I am.
Yes.
To just pick up on the alternative suggestion that the order should sit behind, I've gone slightly off the tangent here, but the order should sit behind the, as it was then, Galliford Try litigation. That decision is a discretionary decision on timing, which again we would say is exclusively a matter for the FTT. It's not a question for this court. So, as I said, there were two limbs to the public purse being the underwriter. One was the Galliford Try litigation. I've covered that, and the other is the public purse point. We say, again, in relation to the public purse argument and whether it's a last resort, you've seen the passage I've read in which they accepted my submission, and we say the FTT gave careful consideration. They give an awful lot of consideration to the public purse argument. They clearly understood it and they analysed it and they rejected it as they were entitled to do at paragraphs 269 to 279. As my Lord Justice Nugee has identified, the FTT was faced with a straight choice. The works could be funded by the public purse or by the developer with responsibility for having brought these building safety defects into existence. It was not an inappropriate exercise of discretion, to put it at its lowest, to conclude that the developer with responsibility for having brought about these building safety defects, to conclude that the latter should therefore fund the works. We would say it's not only a reasonable decision, it's the right decision. And reimbursement sooner rather than later at the cost of the responsible developer or its wealthy associate was a legitimate approach for the First Tier Tribunal to have taken. My learned friend emphasised the articulation of the way in which it was expressed by the FTT about the balance of the money sitting in Get Living's account, as I think his focus on Get Living in that context was, well, they weren't the developer. They weren't talking about SVDP. But that simply was to reflect the reality of the position looking please at paragraph 227 of the decision, page 192, where the financial position of SVDP is identified and its net I'm reading from line 5, its net asset position was underpinned by fixed assets in the form of illiquid real estate, which would take time to sell. So it's not that it's got no money, but it had no value, but it was all tied up. Its current asset position was negative with net liabilities, and cutting it short, it was reliant entirely on Get Living for support. And so it was therefore, in that context, entirely right for the FTT to ask itself or test itself against the proposition in paragraph 270 on page 202, where 4 lines up from the bottom, they say of my learned friend, he found it difficult to identify a clear and convincing reason why it would be just and equitable to allow the best part of 20 million to remain in Get Living's bank account. And just to be clear, that's because SVDP don't have, their cupboard is bare so far as the bank account is concerned. Get Living have assets and value running into billions of pounds, earning interest, or to be put into account for its benefit. And then here's the evaluative point, rather than being returned to the Building Safety Fund, where it could be used to remediate other buildings. So there was the exercise of evaluation. And in that context, we rely on the finding of fact, paragraph 190, on page 186, which records 4 lines up from the bottom of paragraph 190, amongst the objects of the Building Safety Fund identified in the guidance was cost recovery from those responsible for the installation of cladding be maximised. Now, I want to come to the grant funding agreement, because in this context, my learned friend says, well, what really matters is whether the terms of the grant funding agreement are being complied with. That's he, at this point in the argument, says, let's look at the terms of that. And we agree to that point. And that's in the supplemental model at section E.
One of the points made by Mr. Selby was that when the VDP was the developer, it was a subsidiary of the Olympic Delivery Authority, which was a public body, so that this was a case where...
Yep.
And you're going to come to that at a different point, presumably.
Yeah,
yes.
I'm actually nearly there, but yes. I'm just going to focus on the agreement.
This page.
So it's the cost recovery provision in page 223.
Thank you.
And it's clause 5.4.1 and 5.4.3. And we say these are important provisions in the context of what we call the public purse argument. Save where there's been an assignment, the applicant, that's EVML, shall use all reasonable endeavours to pursue reasonable remedies available to it. Those are described as the non-ACM remedies. They've got to provide information about what they're doing, that's 5.4.2, and then this, if the applicant recovers any amount from the pursuit of non-ACM remedies within 12 years, I'll come back to that, it shall, within 10 working days of receiving the same, notify DLUC and then promptly pay DLUC. So there's the contractual structure. Now, the FTT in this case has found that the RCO, the application for an RCO, falls within the ambit of a reasonable remedy available to it. They make that finding at paragraph 210 of the decision. Page 189, about 2/3 of the way through that paragraph, they say EVML has now associated itself with these applications against SPDP, I've explained to you, which, if successful, will provide a much swifter and more convenient route to reimbursement fund. That's the first point. And the second point, whereby we know that they're treating, the FTT is treating the RCOs as part of the obligation, is because the conditions that were attached to the RCO they made are structured around clause 5.4 of the grant funding agreement. So they're embedded in the order, the RCOs that were in fact made. The point here, which we say is really quite important to this public purse argument, is that in obtaining the BSF funding in the first place, EVML contractually acknowledged that the loan to it was subject to repayment in circumstances where it was accepting an obligation to pursue reasonable remedies and then pass up the money when it did. So the loan is subject to the pursuit of the RCO remedy. It's therefore topsy-turvy to say that the existence of the loan is a reason to refuse the RCO. It's the other way round. That's the whole structure of it. My learned friend drew some support from the fact that clause 5.4.3 had a lengthy period attached to it of 12 years, as somehow suggesting, I suppose, a sort of sleepy indifference to the amount of recovery that might be made. We absolutely don't accept that. The fact is that the length of the period shows a very generous period being allowed for the prosecution of claims, but the promptness of payment is 10 days. As soon as you get the money in, you've got to pay it over, and you've got to use reasonable endeavours to pursue reasonable remedies. So you can't sit around for 11 of the 12 years, because that would not be taking reasonable endeavours. So we don't accept that the length of the period which Maloney is alighting on is an indicator in his favour, quite the reverse. So my submission is therefore that reliance on the grant funding agreement as an answer to the RCO is inconsistent with the terms upon which the loan was given. My learned friend's next point is the ODA point, which Justice Nugee has just mentioned, which would be bespoke to the facts of this particular case. Can I just say that there was some evidence below about whether the Olympics were a hugely profitable venture or a loss-making one. I've discussed the transcript with my learned friend. I don't need to give you the figure, it's probably a matter of public record, but it was a significant loss was resulted from the venture. But more immediately, the element of public funding was reimbursed in our immediate context of the Athletes' Village by the sale of SVDP to a private entity, QDD-AV. And that is the end of the public's role, so to speak, or the public interest element in it. In our submission, it's simply a historical fact on which nothing turns in the immediacy of work now having to be done. I just want to take you to some paragraphs of the decision on this. So there's paragraph 254. There's also a point, I suppose I should firstly say, although my learned friends trailed the coat of the ODA, the point is the ODA was constructing its development through the vehicle of SVDP. So it's a corporate developer, and for these purposes, although in a lay sense one's talking about the ODA, it's the company that was the developer, and the company is the respondent to these proceedings. The ODA happened to have been the owner at the material time, but we know that that's not the relevant consideration. So paragraph 254, page 198. As for the fact that SVDP, note the company, was originally in public ownership through the ODA, that's irrelevant for the same reasons. And the reasons, he says, are the same, are we're not concerned with the ownership behind the scenes, so to speak. And then this, in any event, QDD-AV had rights against the ODA, which it had released for valuable consideration. So a couple of points here. Two reasons are given in relation to the ODA point, as my learned friend would describe it. The first is that it's not relevant. The second is that even if it were relevant, quotes, in any event, end quotes, those rights were disposed of. And as I said, I'll come back to that in a moment. But the point is that the purchase by QDD-AV was with a package of contractual rights and warranties. They had their own opportunities to get contractual protection in relation to that. And then paragraph 276, it's paragraphs 187 and 188. So this is a section dealing with the ODA, and it describes the contractual arrangement. And then 187, the SPA of 9th of August included guarantees of SVDP's liability in favour of QDD-AV. QDD-AV no longer has the benefit of those guarantees because in January 2020 it entered into a settlement agreement with the Department of Culture and Media and Sport by which they were released as part of a package. And a finding, so that's a finding of fact, and then this at 188, that settlement was concluded after Grenfell and after it was known that East Village suffered from serious cladding problems, including the presence of ACM, but before the extent of those problems have been identified. So commercial decision taken, aware of at least the risks. And so even if it was relevant that back along many years ago that SVDP had public ownership, it doesn't lead anywhere in the end. My learned friend supplemented his arguments about why the public purse should be a relevant consideration, or reimbursement of public funds was not a requirement, based on Sir James Eadie's concession in the Adriatic case, that the government, so to speak, bore some responsibility for the regulatory regime which existed. And I sense my learned friend yesterday was saying, well, therefore, one shouldn't look at the public purse as being, as a concept, whiter than white, I suppose. Well, 2 points about that. Firstly, that wasn't a point raised below. It's been raised, jumping, so to speak, on what Sir James Eadie said. Secondly, and therefore it wasn't a matter of matter in respect of which the FTT could have reached an evaluation at all, because it wasn't raised. But in any event, it's a bad point, respectfully. The fact that governments, the regulatory system might have been the subject of criticism isn't the fault of the taxpayer, who would now be bearing the cost rather than get living. And isn't a reason, therefore, to change the conclusions of the FTT in relation to the public purse. After all, there is the finding, which I've already taken in paragraph 270, that in this particular context, the balance here is between the money staying with Get Living or being returned to the Building Safety Fund, where it could be used to remediate other buildings. That's the key. It's not just about funding, it's about the use to which the funding can be put. My learned friend's big point essentially is, well, all of this work is fully funded, the works are underway, and therefore no need for an RCO. Well, we've given our answers to that, but I would also add this. The mere fact that works are underway or are near completion is not an answer in every case to section 124, because section 124 is also concerned with costs incurred. This isn't a retrospective point, I'm coming to retrospectivity, but you can always claim an RCO for expenditure that has already been incurred, even if it's incurred in 2026. So past costs are an inherent part of this regime. The fact that works are funded and underway is not, therefore, a complete answer. It's a factor, but it's not an answer. And one can well see cases in which money has been spent and yet it's just and equitable to do so. Of course, a key part of section 124 is prospectively to get work done, but it plainly doesn't limit itself to that. And one can see examples where historic work already completed should be encompassed within an RCO. The subject matter of the triathlon costs in this case being a case in point. I've already made that in a different context. But there might be others. For example, suppose you have a generous benefactor or charity that decides to pay for remedial works. We've already heard that the Building Safety Fund is not available for all types of works, only for cladding works. So you could have a generous benefactor or charity grouping together to pay for remedial works and then wanting an RCO having done so against the developers. In either of those, in those types of cases, or leaseholders grouping together, the FTT would still make an order in our submission against the developer, even though the works have been completed. So those are my submissions on 1.4. On 1.5, the ground 1.5 is triathlon should be, in effect, should be made to seek to use its own other remedies, civil remedies, and not entitled to pursue the RCO. Our answer to that is consideration of that and the weight to be attached to it was inherently within the FTT's discretion. It was fully evaluated by them at paragraph 261. The fact that the works were funded and underway was taken into account, but ultimately rejected, and that's paragraph 269 and following. And the availability of other remedies should not be, in our submission, a reason to disallow an application. There's nothing to suggest that an RCO should be a remedy of last resort. It has huge advantages, which are clearly intended by Parliament. They are quicker, they are cheaper, and as my learned friend himself has prayed in aid, they do not require proof of breach. My learned friend says, paragraph 57 of his skeleton, that the rights of and interests of the respondent are not being sufficiently accounted for in this exercise. It's paragraph 57, I'll just quote what he says. The fact that section 124 provides a non-fault-based remedy is an important consideration against the making of an RCO against a respondent, because it means the respondent has to bear the whole cost of the remediation works and is precluded from seeking contributions from others that cannot be the subject of an RCO, particularly contractors and consultants. Well, the position is that the respondent's rights are being maintained. It's simply chosen not to use them yet. We've heard a very recent pre-action protocol letter, or in the case of the ODA, has disposed of those rights. So there ought to be scant sympathy there. Ground 1.6, this is a ground that relies on the context of the applications, the Building Safety Fund. I'm not quite sure how it's expressed, but essentially, if I put it in a simple way, the notion is, well, we all work together in the common endeavour of getting the Building Safety Fund as part of the remediation project. As part of the development of those discussions, a broader scope of remedial work was adopted, and it's very naughty of you, having secured that, to then go around and make us pay for it through a remediation contribution. That's, in essence, what ground 1.6 is. And we say there's absolutely nothing in this, and that, as the evidence, as the findings of fact show, Triathlon acted entirely responsibly. The first point is the finding that the BSF funding was sought at our request is at paragraph 191. That's the paragraph that my learned friend relied on. But that is a finding at a stage in which the applications were precautionary. Applications were made by EVML at Triathlon's request. Precautionary as the existence of the defects had not yet been confirmed. There were some time limits imposed on applications. And my learned friend says, his submissions in writing at least, I don't think he used this expression yesterday, was kick in the teeth. That's the notion is that to turn around after the event and apply for an RCO is a kick in the teeth. And we made the point in our skeleton that this argument was barely run in the FTT. It got the slightest of mentions, and we've exhibited 4 lines from the oral submissions in which my learned friend got within that territory, but only slightly. And the point is that Triathlon's decision to seek a remediation contribution order is not an act which is inconsistent with anything that it had previously promised or said. It had acted entirely transparently. No agreement, whether legally binding or otherwise, by Triathlon not to pursue SVDP or Get Living is alleged by the applicants, nor could it be. This whole picture needs to be viewed in any event in the light of the emergence of these new provisions, which were either as part of chronology not yet in force or were newly minted when their scope and extent was untested. We just briefly go through the chronology. I think we've already heard Part 5 emerged in the parliamentary consultation process in February 2022. The BSA was enacted in April 2022. Paragraph 203 of the decision, the FTT found that the Building Safety Act added to uncertainty, and at paragraph 204 they record that the enactment caused divergence of interest and tensions at board level within EVML. And then, if I could go please, in May 2022, in the supplemental bundle to section D, tab 2, D.2, page 147.
Sorry, can you give me the...
So it's supplemental bundle,
Yep.
section D,
Yep.
tab 2, page 147.
Thank you.
You should have a letter of the 26th of May 2022 from Triathlon to, this is the operations person at EVML. And in that context, in May 2022, at page 150, you can see in the paragraph that begins notwithstanding, just by the hole punch, notwithstanding, we recognise that it is in all stakeholders' interest to implement a comprehensive scheme of remedial works and to promptly pursue the available funding options for those works, including the Building Safety Fund, and pursuing those responsible for delivering and guaranteeing of the original design and construction of the buildings. And then over the page, a threat to EVML in the final paragraph that if EVML chooses to embark to progress matters in a particular way, will be compelled to embark on formal routes of redress, Triathlon reserves its right to apply for a remediation order. So, except not an RCO, but a remediation order. So the point I'm making here is that in May 2022, and this was before the comprehensive scope of remedial works that was subsequently agreed upon came into play. It's clear Triathlon was flexing its muscles in the uncertain world, threatening the pursuit of those responsible, which obviously would include the developer, and secondly, exercising rights, newly minted rights under the Building Safety Act. And then another letter in the same bundle at tab 4, 16th of June 2022, again another letter to EVML, and I wanted to just draw your attention please to page 163 regarding your queries in relation to Schedule 8, paragraph 2. Triathlon's current thinking as relevant landlords is as follows, and then it sets out a structure. And you can see the emergence of thinking by Triathlon here, particularly in relation to the last bullet point. SVPH 1 and 2 are associated with a person responsible for relevant defects, as SVDP was the developer, and SVPH 1 and 2 and SVDP are all ultimately controlled by Get Living. So again, there's no doubt where Triathlon's was coming from, and to suggest that the making of these, well, just to carry on with the chronology, that's 16th of June 2022. Then the Building Safety Act comes into force 28th of June, as we know, and then on the 9th of December 2022, in section D6 of that bundle, you will see at page 166 what used to be called a letter before action in relation to these RCO proceedings against SVDP, and a mirror image letter against Get Living at page 164. So those are December 2022, and then the funding agreement is June 2023. So we acted entirely transparently. We've done nothing wrong, no kick in the teeth. And in any event, it's not inconsistent for EVML to secure funding under the Building Safety Fund, and for Triathlon to seek a remediation contribution order. They're not inconsistent in any event. Ground 1.7, this is the ground that says that the funding from the BSF was provided irrespective of the position under the Building Safety Act. So it's looking at the interplay between the Act and the fund. And my learned friend says that the willingness of DLUC to provide funding should be a factor in SVDP's favour, and the FTT should not make an order that goes behind that. The FTT in our submission was right to conclude that this was at best a neutral point. This is paragraph 273. Page 202, 4 lines up from the bottom. In any event, it is within the discretion of the FTT to so conclude. And here, in a sense, I repeat the submission I made earlier, which is the terms of the funding included the obligation which I've looked at and taken the court to. Funding was always subject to the reimbursement obligations, and therefore it's the other way round. My learned friend then averted to countervailing points of public interest being relied on. This was paragraph 65 of his skeleton, about the housing market, the impact that these types of orders might have, and so on. There was no evidence about any of that below. And so to pray in a countervailing points of purported public interest or policy have no place in my submission here. The one thing that we do know is that the response to Grenfell was the Building Safety Act and section, amongst it, section 124. That's the real and relevant consideration in our submission. And last point, really, the concession from my learned friend, which is recorded in the FTT's decision at paragraph 270. Mr. Selby, is page 202, Mr. Selby recognised the attraction of the proposition the public should not have to pay for work. And then he said, then the tribunal say, although he asked us to resist that way of looking at these applications, he did not suggest that protecting the public purse by securing the earliest possible reimbursement of remediation costs was irrelevant. And he has not suggested otherwise yesterday. So it is recognised that securing the earliest possible reimbursement is an irrelevant consideration. And we rely on that position. So that's 1.7. I think anything else I say in relation to that would be lifting points I've already made from other grounds. Ground 1.8 relates to the changing identity of the ultimate beneficial owners of SVDP and Get Living. this is all about, well, the people behind the scenes, they weren't there then type of argument. And my learned friend, with the greatest respect, is stuck with the findings of fact in relation to this, which are material. So paragraph 174. On page 183, this is get living. Paragraph 174. Get living involvement therefore commenced after Grenfell Tower, and as will be seen, after concern was first expressed. Whether that chronology is of any significance in these proceedings is a different matter, since the insertion of an additional level in the corporate hierarchy to secure tax benefits did not change either the ultimate ownership or day-to-day management of the estate. That continuity is apparent from Get Living press releases and publications, including its 2020 accounts and 2022 reports, both of which claim involvement with East Village going back to 2013, i.e. the Olympic period. The Get Living brand was applied by QDD AV to the private rental units at East Village from mid-2013. And in that context, we've put in the bundle, if I could just take you to the supplemental bundle at section D1, page 142. One of the documents, there were many, but one of the documents that was before the FTT is a publicity document from Get Living, dated the 15th of May 2013, telling the world how Get Living was proposing to offer accommodation in the post-Olympic period. So this backdates to 2013.
So which particular bit should we be looking at?
Well, it's produced. It's called Get Living London, are the producers, the bottom right-hand corner, and then in italics, just below the strip that says 15th of May, you can see Get Living, a residential owner and rental management company, launches today.
Oh, I see. Yes, I see.
And the Get.
Yes.
As the tribunal finds, the Get Living brand
Yes.
was applied by QDD AV to private rental units from mid-2013. So I'm just showing you a live document as an example of that sort of this is all part of the point of Get Living saying, oh, we only existed much later, we had nothing to do with it.
Yes.
But it goes on to say in the middle paragraph, the first Get Living London homes will be available at the former Athletes Village
Exactly so.
this summer.
Yes. And then paragraph 253 is the other finding of fact, which is material. Paragraph 253, page 198. Staying on the Get Living theme for these purposes. Paragraph 252 is all about the corporate identity of SVDP, but on 253 we deal with Get Living. The same applies to the fact that Get Living was inserted in the corporate structure only as late as 2018. When it acquired East Village, it acquired both its assets and its liabilities. Additionally, as Mr. Millett KC put it, Get Living is the latest holding parent in a group which has been involved as owner of East Village since 2014 and as prospective purchaser since 2011. So that's the Get Living side of the story, and we say that analysis is a factual position, but it's also one inherently for the FTT to consider. So far as SVDP is concerned, and the key paragraph here is the one above, paragraph 252. And this is about the changing ownership. As Malone for Mr. Selby tried to put it, the SVDP of today is not the SVDP of the past. But of course, it's the same company. And the tribunal acknowledge some of these features. Mr. Selby is right that the Act erodes and elides corporate identity. It does so for specific purposes and so on. It doesn't require the normal consequence of incorporation to be ignored for different purposes. When QDD opted to acquire SVDP, it could have taken a transfer of the land and buildings, leaving liabilities of the developer behind. It chose not to for its own reasons. This is the important feature in the analysis, knowing that it was acquiring not only the assets of the partnership, but also its liabilities, including latent and consequent liabilities. The same is true of each of the investors who have subsequently bought into the corporate structure above SVDP, each willingly assumed the risk associated with their investment. And so at each stage when these people entered into the contractual story, they had opportunities to secure remedies and rights. That is an important consideration. They acquired rights, and in the case of the ODA, as I've already mentioned, chose to dispose of them. And each of these entities understood the risk. And let's be clear, the risk of latent defects is always a problem when one is buying a building. The fact that the scale of the problem is as significant as it has proved to be, and Grenfell and all the rest of it, is not the point. The point is, you always, if you're prudent, take the relevant precautions in your remedies when you purchase. And it's in that light that there should, in my submission, be scant sympathy for the fact that the owners behind the scenes were not the people who actually carried out the development. Ground 1.9 is this is the argument that the terms of the grant funding agreement expressly prohibit a claim being made against Get Living. And this is supplemental bundle section E, tab 3, page 218. Now, before I begin on this topic, can I make this clear? In a sense, this is a prohibition which is said to apply to my learned friend Mr. Polly's client, EVML. It's not a prohibition against me. Against me, it's put, well, the context of the prohibition against EVML is a factor which makes it unjust and equitable as against me. But because it directly concerns EVML, Mr. Polly is probably going to spend a little more time on it than I will. But I'm going to outline the position so far as we're concerned. And the first point is obviously that the FTT's decision in relation to this paragraph 273.
The paragraph is?
Paragraph 273 of the decision. It's dealt with by the FTT there. It's about 5 lines down. Mr. Selby went further and suggested that the grant funding agreement prohibited EVML from pursuing claims against Get Living as an associate of a leaseholder, an optimistic interpretation of the agreement where Get Living is also an associate of the developer. And he said those points, the tribunal said those points seem to us at best neutral, and so rejected it. So the first point we make is that if you have the agreement to hand, page 218, supplemental bundle, as I've already made clear, it's a prohibition, so it's an undertaking warranted by the applicant, that's EVML, and the purpose of the prohibition is clear. It's to stop EVML, the BSF applicant, from seeking to recover the costs to which the funding relates by way of service charge from its leaseholders. That's the rationale behind it. It's giving purpose to the regulatory regime. To suggest that this stops EVML from applying for an RCO against Get Living as the parent or associate of the developer and freeholder is, if I may say, Alice in Wonderland. And that, perhaps less colourfully, is what is being said by the tribunal, i.e., why should it stop Get Living being made a respondent as an associate of the developer or freeholder. Very shortly, the points we make are these. Firstly, Get Living is made a respondent in these proceedings as associate of the freeholder, not in its capacity as a party that controls a leaseholder. It's the happenstance that it's the parent of the freeholder. It's happenstance that the parent of the freeholder also happens to be a party that controls a leaseholder within the definition. But that's not a basis for operating the agreement in this way.
Can we just understand how this fits with the clause? This is clause 4.3.1, isn't it?
Yes. So obviously this is my learned friend's contention, but
yes.
The way he puts it is this. The prohibition is against claiming the cost of qualifying expenditure which is funded by the agreement, from any leaseholder.
And the definition of leaseholder is back at page 204.
Yes, and at page 204 one sees a leaseholder being a person other than the applicant that is party to a lease document. So
And
the other than the applicant means essentially not the landlord or management.
Yes.
So you're on the other side of the fence, so to speak. You're the leaseholder, and you're party to the lease document. But it's also under B, any party that controls any person that is party to a lease document. So in the property hierarchy, Get Living sits above a whole series of Get Living N26 limited companies who are leaseholders.
Just so I understand properly, if we go back to page 17
Of
in the supplemental bundle, behind tab 4, A4.
yes,
So this is the property structure.
yes,
So EVML is the landlord in relation to QDD EV N26.
yes, and there are lots of those. I mean, here there's there are lots of sub-leaseholders.
So there are several leases in relation to QDD EVN26, and then QDD EVN26 has entered into numerous sub-leases. Yes, I see. So QD Get Living is not itself a party to a lease document to the capacity as lessee, but the reference to control creates the issue.
That's how it's put.
Yes.
I anticipate that Holly may want to say more about
Yes.
it, but that's how it's put. But
Yep.
I'm taking in a sense, a lighter touch to it,
Yes.
which is to say, on any view, it was never intended that the parent of the freeholder or developer should be able to avail themselves of this provision.
And I suppose there is a sort of point about the relationship between 4.3.1 and 5.4.1.
Absolutely.
Yeah.
Absolutely. and we respectfully would endorse, and one sees immediately below the definition of leaseholder is leaseholder's contribution. So it's all about the service charge. It's not, and that's the capacity in which one's looking at these questions. That's the. And so far as the question of construction is concerned, I'll leave that to Mr. Polly. But so far as triathlon is concerned, and looking at it in the context of these applications, as opposed to what may happen.
You weren't party to this agreement. You're not contractually barred.
We're not bound by it. We're not party to it. And these proceedings are not a breach. EVML has not claimed the cost against Get Living. Triathlon is the applicant. EVML was not a party, not an applicant. So there's no breach of the provision that stops the FTT in any event from making an order against Get Living. And in the real world, obviously DLUC and the GLA themselves would never want to enforce this provision for obvious policy reasons. They're the party to the agreement.
I mean, just looking at the literal construction, you say Mr. Polly's going to come to this, but it's not just not claiming the cost. It says, shall recompense leaseholders, on this hypothesis, Get Living, recompense Get Living for any expense that Get Living has incurred in paying for works reimbursed by the fund.
It's a complete affront to everything that the RCO is intended to achieve. I mean, I take Alice in Wonderland, and that's why. Those are my submissions on 1.9. 1.10, public funding, matter of last resort. I don't think my learned friend added anything, either written in writing or orally, to what he'd said elsewhere, so I'll do the same. Can I summarise that the way we put this case is that the remediation contribution order is properly made in the exercise of the RPT's discretion, and that all of this legislation points to this being a paradigm case in which the original developer, SVDP, is responsible for the relevant defects, and in circumstances where it is illiquid, Get Living is properly made a separate respondent, and therefore the tribunal was right to exercise its discretion. And what is, in a sense, below the line is the package of rights that SVDP has been provided through the extended Defective Premises Act regime to secure reimbursement from what one might call the really responsible parties, which is the Galliford Tries and so on. But they take the burden of doing that. And that's not altogether surprising. This is a point that crops up, I suppose, in ground 2 as well. But if one thinks about it sort of societally or in structural terms, it's right that the developer should bear responsibility for the huge cost, expense and complexity of civil proceedings under the DPA. And the leaseholders, who are, I speak for any individual people, but generally ill-equipped to participate in that kind of process. This is, in my submission, the right way round. Unless there's anything else, I'm going to move on to retrospectivity in ground 2.
Just before you do, sorry, go on.
I have one question, which is, I'm sorry, it's probably all there in the decision, but I've not quite understood the distinction between ACM cladding claims and non-ACM cladding claims. So we looked at the grant funding agreement, 5.3.4, whatever it was by reference to non-ACM cladding claims.
So the ACM is the material.
Aluminium, yes.
Yes, it's the material which was on Grenfell, which was acutely combustible and the significant immediate concern. So there was a separate sort of funding stream for those types of cases. And indeed, in the records we had in this case, the blocks were analysed by reference to whether they were ACM or non-ACM. Non-ACM cladding is combustible cladding, but it's not as serious, if I can put it very clearly.
And what we're concerned with in this case is all non-ACM costs. Yes. Thank you.
Just before you leave ground one, going back to the grant funding agreement and the vexed question of clause 4.3.1, the undertaking is given to the department and the Greater London Authority.
Yes.
But it says leaseholders may enforce. Now, on Mr. Selby's hypothesis, Get Living is a leaseholder. So it strictly, on the face of it, can enforce, and therefore it can enforce EVML's obligation to recompense it for anything that it's incurred in paying for works reimbursed. So if GL hands over the money to EVML, can it say, well, now we'll have it back, please, under 4.3.1?
My position is, firstly, that would be an affront to common sense. But I'm not, as I said, I'm not directly concerned with this.
No.
My case is, I'm not part of this agreement, and I'm not in breach of it. My
Mr.
friend
Polly
will have heard your lordship's question.
Yes.
Assist you with it. Then retrospectivity. My starting point is that the whole point of this legislation was to correct the wrongs of the past, and so it would be a remarkable outcome if costs incurred in the period prior to enactment were not included within its remit. Retrospective is itself a term that has a sliding scale. There's scales of retrospectivity, and we would say, at the slightest end of this, merely because what the legislation is doing is impacting to a degree on facts that happened in the past in this context of section 124. You could say that's retrospective in the sense that it's capturing costs incurred before enactment, but it's not retrospective in the sense of backdating a limitation period or anything of that sort. So and we associate ourselves with the Secretary of State's skeleton in the Adriatic case, paragraph 38, which I won't take you to. The starting point, we could go to the legislation at tab 4 of the call authority file on page 20, page 89. Section 124, subsection 2, the remediation contribution order is an order making payments for the purpose of meeting costs incurred or to be incurred in remedying relevant defects. So, and that, a relevant defect is defined at section 120, subsection 2. So we go back to that. That's in a different tab, and it is page 23 of the bundle. section 120, subsection 2, relevant defect means a defect that arises as a result of anything not done in connection with relevant works. Relevant works are then defined in subsection 3. But subsection 3A, relevant works means any of the following: works relating to construction or conversion if the building was completed in the relevant period. And then B, also works undertaken in the relevant period. And the relevant period means the period of 30 years ending with the time the section comes into force. So the whole catchment, if you like, is relating to defects that were brought into existence within the period of 30 years. So my first submission is there's no obvious logic that would require the expenditure necessary to remedy the relevant defect only to be incurred prospectively after the commencement of the Act. To construe it that way is to preclude those who reacted promptly to the Grenfell fire. And I include for these purposes Triathlon in relation to the expenditure which it was required to commit. And it's of interest, as a jury point I suppose, that Mr. Allison in the Adriatic case makes that point at paragraph 65 of his skeleton. That's Adriatic Core, page 99, tab 5.
Sorry, what was the paragraph number?
It's paragraph 65 of Mr. Allison's skeleton, and it's Adriatic Bundle, tab 5, page 99. And I'd invite you to bear in mind that this is not about, or not only about, remedial works in the traditional sense. Mitigation costs, such as waking watch, were put in place almost immediately. The chap sitting in the chair at the end of the corridor. And it doesn't matter how we got there, but ground 3 in this appeal acknowledges that waking watch is a recoverable cost.
Recoverable as a result of the 2024 Act, if not otherwise.
Correct.
Can the fact that that came in with the 2024 Act really help us on deciding whether Section 124, as enacted 2 years earlier, is retrospective?
Well, no, but I'm simply saying that perhaps waking watch is it's an example, but temporary measures, fire alarm sprinkler systems, there were temporary measures put in.
Soon after 2017.
Exactly. And waking watch is the wrong side of that debate. I wouldn't say it is, but if it was, so be it. But physical work was done. And there's no reason in our submission why it shouldn't be just and equitable for a developer to be ordered to pay all of those costs, even though incurred pre-Act. To do otherwise would split up the remedies so that leaseholders would have to bring RCO claims for post-June 2022 costs and complex DPA proceedings in the High Court for pre-costs, because that would be the only remedy which was left to them. And as I've indicated, litigation in the TCC would be a lengthy process. It would involve cost shifting. It would be, in our submission, be the wrong environment. The truth is leaseholders would be ill-equipped to use it. And they get bogged down in the complexity of those cases, which involve multiple parties. It's one of the features of the RCO is that you go against the developer. You choose to go against an associate, that's your choice. But the problem with TCC litigation is the endless capacity to pass the past responsibility down the line. We all want time to serve their defences and all the rest of it. And that's why these proceedings take so long. And to hive off that catchment of cost and require leaseholders to go down that route would, in my submission, be unsatisfactory and indeed cause confusion, particularly when you have costs that sit on the borderline, so far as that is concerned. So that's the sort of opening remarks that I would make so far as retrospectivity is concerned. So far as the test is concerned, learned friend and I are agreed about that the FTT applied the right test. That's the l'office sheriffien criterion in paragraph 62 of the decision. The case itself is elsewhere, but it's correctly set out.
You're quite right. Mr. Selby said, well, the FTT got the test right. Both in this context and in the context of Adriatic. I wonder whether there is something to be gained by thinking about the law in a little bit more detail. The concept of retrospectivity, retroactivity, what the law is concerned with is very much explored in Wilson and First County, especially by Lord Roger, with whom these two of the others expressed some agreement. Rather more recently, I see in the Adriatic bundles there's a case called Granada, which I was involved in, where some of this is discussed. Arguably, the Granada type situation favours you, but I just wonder whether it's rather simplistic to say, well, Lord Mustill and go no further.
Well, as I say, it's a slightly unusual scenario because, as I said, we're agreed between us
Yes.
here, and bad say I'll confess, I haven't done an exhaustive review. I mean, if the court would be assisted by that, obviously I may have to come back tomorrow to do that. I think as I said, I would summarise the position being that it's not. I think on any view, it's not a binary question. Is it retrospective or not? There's a sliding scale.
And I follow that, and I think you get to some extent from the authorities a sliding scale from what are obviously accrued rights through to applying the law for the future in relation to a past situation.
Yeah, you're correct, and we're very much at the latter, which is that the claim happens to involve a fact pattern that involves things that happened in the past, and that's retrospective only in the lay and loosest of senses, and that, if I could summarise, that's very much where we are, and therefore the degree of unfairness should be viewed as a very different way from the catchment of something that adjusts parties' pre-existing rights in a far more fundamental way. The reasoning of the FTT was based on 4 features. Firstly, the clear language, the absence of any temporal limit applied to the word incurred, and the absence of any transitional provision, which they said was telling. That's paragraph 73 of the decision. In other words, it does not say incurred after 20th of June. That's the first factor relied on. The second factor was paragraph...
I mean, that's of itself, I don't know how much you do get from that. That seems quite neutral. Because plainly, even absent any retrospectivity or retroactivity, whatever one calls it, incurred or to be incurred makes sense.
I acknowledge that it's capable of that alternative meaning, but it would not have, if they had not thought it obvious in my submission, it would have been possible to put in a date if that had been thought material.
Yes, I mean, that might be thought to be the wrong way round, at least in the case of starker retrospectivity, because the presumption against retrospectivity says you assume there isn't retrospectivity unless Parliament says so clearly. So merely to say, well, it's ambiguous, but they haven't put in some words, might not be thought to help.
Yeah. Well, as I say, we submit that it is obvious, and viewed in its context, which of course it's not just focusing on the words, it's viewing in their context. The context is the legislative background to which I referred, which is all about the need to remediate building safety defects. It becomes obvious. That was the first ground. The second ground is paragraph 10-12 of the explanatory notes. I don't think I need to take you to them, you'll recall them. It's Core Authorities, tab 14, 393, which I think grudgingly my learned friend accepted was consistent only with them having the author of those notes consistent only with them being retrospective, because it was saying that leaseholders who had paid could use the RCO machinery.
I mean, at the moment, I'd assume that wasn't available to Parliament. Has anyone found out otherwise?
I'm not suggesting otherwise. But as I said, it is a comprehensive document by an author with an overview of the entire scheme and how it all hangs together and commands weight in those circumstances. And then third reason given is the inconsistencies in the way that it would treat leaseholders, for whom, of course, the benefit of the Act was primarily designed, if you were to have the arbitrary cut-off. And that's paragraphs 76, 77 and 78 of the FTT's decision. And
Sorry, which paragraphs again?
76,
Yep.
77 and 78. I won't take you to them at the time. And the fourth reason they gave was consistency with the decision in Adriatic land, meaning that sections 124 and Schedule 8 were different routes to the same destination. That's paragraph 79 of the FTT's decision. And we respectfully endorse those reasons and invite you also to look at Mr. Allison's submissions to the Upper Tribunal in Adriatic, where he accepted, and I think he also did an oral argument, that section 124 is retrospective. So the landlord, in those circumstances, accepts that section 124 is retrospective. So far as...
I think arguably it suits him to accept that.
Well, it may do, but
Yes.
but
But the mere fact that a party whose case is helped by the concession makes the concession may not take one very far.
well, I'm inviting you to read the reasoning, I suppose, rather than the fact. But it's just shorthand. My learned friend sought to rely, by way of comparison, on various other legislative provisions, which in respect to which retrospectivity, and I'm using it as now a generic term, even though it's a sliding scale, takes effect. And the first of those was, one of those was section, well, I should start with section 135, which is page, tab 4, page 51. This was the change in the limitation period in respect of Defective Premises Act claims, allowing you to go back as the complementary enactment, we say, to section 124. And the safeguard in subsection 5 about breach of convention rights and so on. And we say that that's a different scenario here, from the one we're looking at here, because it is changing the existing law in contrast to the creation, as section 124 does, of a newly created cause of action. It's saying that you're actually changing the substantive law, so there is a clear distinction to be made, and that's one, again, that the Secretary of State makes in Adriatic. You contrast the alteration of existing rights and obligations retrospectively with the prospective introduction of rights and obligations arising from pre-existing legal relationships, and that's the contrast. And it's for that reason that it's necessary to protect existing rights through the Convention in Section 135. So it's Section 135 is an entirely different piece, not comparable. No one is suggesting that we were being given a remediation contribution order for which a limitation period goes back in time. And a similar position obtains in relation to Section 130. This is the building liability orders. So, just to, this is page 42 of the bundle, just to remind you how building liability orders work. So, you have the paradigm case is you have a claim under the Defective Premises Act. Let's assume it's, of course, the developer can be both a claimant and a respondent under a DBA claim, but let's assume a developer who's been the subject of an RCO. So he's the claimant. He can sue the contractor under the DPA. If the contractor has not got sufficient assets, Section 130 allows a building liability order to be made against associates of the defendant contractor. One sees in Section 130 that the building liability order is made in respect of what's called a relevant liability. And the relevant liability in subsection 3 means a liability whether arising before or after commencement, which is the language Malone and Friend relied on, that is incurred under the Defective Premises Act. So it's defining the relevant liability by reference to the liability that arose before or after commencement of the Act, excuse me, under the Defective Premises Act. So the Defective Premises Act is existing legislation, so there is a need to clarify the position in relation to relevant liability. So although the order that is now capable of being made, Section 130 building liability order, is new, it depends on a pre-existing definition. Well, so it depends on a liability under the Defective Premises Act. So clarity is required, we submit, to explain the position so far as limitation is concerned, that it's not just talking about a liability that arises since the introduction of the Act. Then Malone and Friend took you to sections 147 and 148. This is the product liability provisions. Section 148 is page 55. Liability relating to construction projects, products. Subsection 2 referred to this new cause of action, and condition A of that new cause of action is that at any time after coming into the force section, those things occur. And then at subsection 8, there's a reference to subsection 10B of the Limitation Act, and it says that the right of action is to be regarded as having accrued when the works were completed, and so on. And one sees a mirror image of that in section 149, where again condition A operates if facts occurred before the coming into force of the section, and then subsection 8 gives the limitation period. So again, these are very different scenarios from section 124. What they are both saying is that you are treated as having had a cause of action at the time stated, which is back in time, and you're then given the relevant limitation period for it. And that's entirely different from the structure of the RCO, where there's no limitation period as such. No one is suggesting that anyone was given a limitation, the right, to bring an RCO at any time before June 2022. The RCOs just happened to involve, on our analysis of the case, some facts that had happened in the past. And so the differential in the way it treats causes of action we submit is telling, and therefore one can't draw the comparisons that the learned friend seeks to draw. There's then a debate between the learned friend and I about the relevance of Adriatic. So the learned friend says Adriatic, that there's little in the determination of this question, ground 2, in these proceedings, that this court won't get anything from the decision in Adriatic. You'll recall that to a degree, the FTT drew on the reasoning of the Upper Tribunal, happened to be the same person, but anyway, it drew support from the reasoning in Adriatic. And my learned friend says, no, even if you, the Court of Appeal, agree with that reasoning, it's a different scenario in our case. And we say that submission ignores two things. Firstly, it ignores the primary basis in Adriatic. Sorry, the primary basis in Triathlon and Adriatic was consistency in a complete code or scheme. And we rely, in relation to that, on a number of features. Section 116, which treat of the Building Safety Act, which treats sections 117 to 11124 and Schedule 8 as a composite package. They're introduced and discussed compendiously. The crossover in the explanatory notes between the two, and the Upper Tribunal's decision in Adriatic, which describes the overall scheme. And so we say they are to be regarded as part of the whole. So far as the language is concerned, the point for our purposes is that Schedule 8 in material part refers to incurred in the same way. That's the core authorities, tab 4, page 78. This is in paragraph 10. I'm not going to get into the debate about the status, but we do rely on the language in 10.2a, no costs incurred or to be incurred. But also in paragraph 9, the word incurred, and paragraph 9 being on page 76. There may be a debate between my learned friend and I about whether Adriatic is a case about the word payable or is a case about the word incurred. We say that if you analyse the FTT's decision in Adriatic, read with Triathlon, that the element of the Adriatic decision on which the FTT, in my case, drew support was in relation to its conclusions on the word incurred. So it analyses the position in relation to incurred, and then it moves on to a different strand of argument. And so the focus should indeed be, in my case, on the word incurred, and one can see from the reasoning the specific paragraphs which the FTT draw from Adriatic being the debate on the word incurred and not on the word payable, with which we are not concerned. And so there's nothing wrong if it be this court's ultimate conclusion that the word incurred in Schedule 8 can go back as far in time as the relevant period requires. but the control mechanism that might temper that might be how you interpret payable. That's a different question. The effect of giving retrospective effect. So if I take you to the FTT's decision at paragraph 78. Page 167. That's where the FTT give their consideration to some of the anomalies that would occur in the event of the respondent's position, the appellant's position being correct. I should just say, small point, there's a couple of references to 22nd of June in there, which plainly should be the 28th of June, which none of us picked up in the transcript. But the point here is that, and I've already made, having a DPA remedy is an unsatisfactory one, and it would be much more sensible in our submission for all of those matters to be resolved through the medium of the Building Safety Act remedies being dealt with in the First Tier Tribunal. Any unfairness on a respondent is mitigated by the LPI regulations and otherwise to Defective Premises Act claims. The fact that they go back over time shouldn't matter because they've got their remedies under the regulations where the buck stops with the developer, and when the buck stops with the developer, they're the ones who are resourced sufficiently to pursue DPA claims in the High Court. I know there was some discussion in the Adriatic case about fire doors.
Yes.
So I did want to say a bit about that. So the tension in retrospectivity is between, on the one hand, I sense, not capturing, when it should, the substantial costs that may have been involved in remediation post-Grenfell in an entirely honourable way, doing the right thing, getting on with repairs, not being dragged through the tribunal system, on the one hand, and leaseholders going back 15 years to say, oh, well, in 2000 and whatever, you made me pay for some fire doors and now I want some money back. And how does one deal with retrospectivity in a fair way that covers both of those scenarios? And it's that really that I wanted to cover. Well, the first point is that if the leaseholders in Adriatic, I'm obviously not arguing Adriatic, but if the leaseholders lose their case in the appeal, they, on my analysis, can go for an RCO, subject to scope about whether costs of an application fall within it. But for that type of cost, they can go against the developer, Land Securities, for whatever costs they may be liable to the landlord to pay. That's the structure of the scheme. The developer, Land Securities, of course, we know is a developer well able to refund and is the party responsible in the statutory sense for whatever these issues are. So far as the fire doors point is concerned, well, the submission was made, parties have always been able to go back in time. There is no limitation period. But there's a sort of pragmatic position, one might say, in relation to that, which is you can't get claims for interest in relation to those things. So the passage of time probably renders the value of those claims, even if permissible in principle, far less likely to be pursued. Whereas the real vice or mischief that is aimed at here is the eye-wateringly large costs of remediation, which have been implemented post-2017, which make complaints about the fire doors pinprick. As I said, particularly if you're looking at something where you're looking at the value of money you paid 10 years ago in today's terms. And even if you were against me on all of that, I would say, why shouldn't why shouldn't the leaseholders be able to go against the developer to say, we've been asked to pay for some fire doors a while back, which you put in, which affected our life safety? What's wrong with that? Obviously, there's a resourcing issue as to having the capability on this hypothesis of the tribunals to accommodate those disputes. But the point is, these are not routinely defective issues. These are not run-of-the-mill, my wallpaper was peeling or you didn't sort the plumbing out. These are defects defined in a particular way, namely that they made the building unsafe to occupy, although nobody knew it at the time. And it's right in our submission that if it comes to that, the original developer should pay for those if they can't get the refund or costs back from the landlord. So in our submission, it's the fire door scenario is unlikely in reality to happen. If it does, it's far less serious than the mischief at which the Act was aimed. And even despite all that, so what if the developer is there? It's his fault. He's the party responsible for the doors having been put in. Then two more points to make. One is safeguards. My learned friend points to the difference in safeguards in section 135 and the others where there's express reference to convention rights and the absence of safeguards which he anticipated I'd be relying on correctly in relation to section 124. The point is obvious that the just and equitable discretion is broad enough to take account of all of those issues. If a party can't defend itself fairly, because it's lost documents or whatever it may be, and cannot have a fair trial, that's a consideration which the tribunal is entitled to take into account in just the same way as it would under Article 6.
That would also apply to the fire doors put in 25 years ago.
Indeed. What the tribunal in our case was saying in paragraph 281 on page 204 is the mere passage of time is not of itself an answer. Because, as it says in the penultimate sentence, the legislation permits this result. Something more is required. And then it posits that it's difficult, merely difficult, not impossible, to think of an example. So one can't simply say...
Which paragraph is that?
I'm sorry, paragraph 281 is the last couple of lines of that. And then the learned friend relied on paragraph 282, or drew that to your attention. But the point is that there, and it's not for me to speculate, but that there may be, as the tribunal itself acknowledged, fact-specific areas of prejudice or unfairness which are not merely the product of the effluxion of time, which render it unjust and inequitable to make an order. And that is the control which Parliament has allowed within the machinery of section 124. And it's important in this respect. There is no A1P1 challenge to the validity of section 124. The breadth of just and equitable encompasses all the safeguards that the other provisions that have far more retrospective effect have, plus more. So that's safeguards. the last point.
You're obviously near the end, but you've got a few minutes to go, have
Yeah,
you?
yeah, I've got five.
In which, shall we break now and come back at 2 o'clock?